Why mediate? Why consider mediation? Mediation is pretty much no risk. There's no downside. 75% of mediation is successful. It's non-binding unless the parties want it to be binding, in which case an agreement is drawn up which can become an order of the court. So it can be final. It is confidential. It is without prejudice, and it is informal and voluntary. So because it's not binding, and the content of mediation cannot be used as evidence in the future, you can come out of mediation and, having not achieved an agreement, you are able to go into back into litigation or into arbitration without having lost anything. So the worst case is reverting to where you are, which is arbitration or litigation, and the best case is, of course, settling. Confidentiality is important because it avoids bad publicity and it avoids rumor mongering. Your mediator will not testify in court. Your mediator will destroy the documents at the end of the mediation. Mediation is voluntary. So that means that you can leave, or the mediator can leave, at any time for no reason at all. Mediation tends to preserve relationships. Burning bridges can be a poor idea. Mediation is being encouraged more and more by the courts. In fact, the courts are starting to frown on parties that are refusing mediation. Courts are getting full, and the attempt to settle by mediation is even being met with penalties in some jurisdictions. Penalties that have been tested, I guess, are, for example, a denial of costs. So even if you win, you will be denied the costs. So the bottom line is this. In more than 90% of cases, settlement happens. The expression settled on the courtroom steps is very real. That means that we spend a lot of time, money, stress to get to a point, to get to the courtroom steps, and then we settle. Doesn't make much sense. And mediation costs a fraction of a litigious process. Consider mediation. It's a smart thing to do.